Good morning and Happy New Year. I hereby call to order this first meeting of the Pennsylvania Public Utility Commission for the year 2025. We welcome everyone joining us in the room today, as well as those joining us on a live stream. Please stand for the Pledge of Allegiance. Before we begin the PUC public meeting today, I want to take a moment to reflect on the life and legacy of President Jimmy Carter, a person who exemplified the true meaning of public service. Though his presidency may have been decades ago, the example he set during his long life of service will continue to inspire and guide us well into the future. President Carter showed us that public service is not confined to a single office or a singular moment in time. After leaving the White House, he rededicated himself to the work of helping others in many different ways. From his leadership at the Carter Center to his countless hours building homes with Habitat for Humanity, President Carter lived his belief that service to others transcends politics and is the ultimate gift we can all give. His decades-long commitment to Habitat for Humanity is especially inspirational because that program goes far beyond building and improving housing. It uplifts individuals and families and provides an affordable path to a better life. For us as public servants, and especially as an agency tasked with finding a balance between safety, reliability, affordability, and universal service, President Carter's efforts are an even more meaningful example. Beyond that, his commitment to promoting peace, fighting disease, and advancing human rights around the globe is a testament to the power of compassion and determination. But it wasn't just his accomplishments that set him apart. It was his unwavering humility and his ability to see the humanity in everyone he met. President Carter reminded us again and again that leadership is not about power, but about purpose. He often said, "My faith demands this is not optional. My faith demands that I do whatever I can, wherever I am, whenever I can, for as long as I can, with whatever I have, to try to make a difference." These words ring true for all of us who serve in government and in public life. They remind us that the work we do is not about personal accolades, but about making a positive difference in the lives of others. As we reflect on his life, let us take inspiration from his example and recommit ourselves to the ideals he embodied: humility, service, and a belief in the inherent dignity of all people. President Carter taught us that no act of kindness is too small, and that true leadership is measured not by what we achieve for ourselves, but what we give to others. So today, as we move forward with the work before us, let us do so with President Carter's legacy in mind, a legacy of compassion, integrity, and service that transcends politics and unites us in our shared purpose to serve our communities and our country. I ask you all to pause for a moment of silence to reflect on a life and example set by James Earl Jimmy Carter, Jr. Thank you all. At today's meeting, which is open to the public, the Commission will act on various matters. Since adequate forums have been made available for public participation in cases before the Commission, there is no opportunity for the public to address the Commission at this public meeting. Public meeting motions, statements, and video will be available on the Commission's website later today. The first matter on this morning's agenda is the approval of the minutes of the meeting of December 12th, 2024. I would like to recognize Commissioner Zerfas as the editor of the minutes. Commissioner Zerfas.
Thank you, Mr. Chairman. I have reviewed the minutes of the December 12, 2024 public meeting and move that they be approved as submitted.
You've heard the motion by Commissioner Zerfas. Is there a second?
Second.
Seconded by Commissioner Yanora. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it, and the minutes are approved by a vote of 5-0. Madam Secretary, we're ready for your presentation.
Good morning, Mr. Chairman and Commissioners, and a Happy New Year. Your various bureaus and offices have prepared the following agenda items for your consideration. Therefore, let us begin on page 1 with matters presented by the Bureau of Audits. It is recommended in an omnibus motion that the Commission adopt both items on page 1, beginning with the Universal Service Program Audit Report for the People's Natural Gas Company, and continue the omnibus to include all 3 items on page 2, and include and end the omnibus with the single item on page 3, the gas cost rate report for the Northeast Heat and Light Company, and release all audit reports contained in this omnibus to the public.
Is there a motion to consider the staff recommendations?
So moved.
Is there a second?
Second.
Motion by Commissioner Coleman, seconded by Commissioner Zerfus. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it, and matters are approved by a vote of 5-0. Madam Secretary.
Turning to page 4, it is recommended by Director Mumford and the Office of Competitive Market Oversight that the Commission adopt the proposed tentative order regarding the waiver of the Commission's regulations relating to timeframes for switching suppliers by customers.
Is there a motion to consider the staff recommendation? Is there a second?
Second.
Motion made by Commissioner Unora, seconded by Commissioner Zerfus. Any discussion?
Chairman, I have verbal.
Vice Chair Barrow.
Thank you. In 2012, the Commission determined that the then existing 16 to 45-day timeframe to switch a customer's account between electric suppliers caused frustration and unnecessary delay. The Commission changed its electric switching rules to create a 5-day waiting period. It already had natural gas switching regs in place, and so it's been waiving the longer natural gas supplier switching waiting period in 3-year increments ever since. It's been almost 15 years at this point, and I hope that we make that change permanent at some time in the near future. Thank you.
Thank you, Vice Chair Barrow. Any further comments? Hearing none. All those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it, and matter passes by a vote of 5-0. Madam Secretary.
Turning to page 5, in matters presented by Director Hafner in the Office of Special Assistance, it is recommended in an omnibus motion that the Commission adopt both items on page 5, beginning with the formal complaint of Jeanette and Craig Pavlik versus the West Penn Power Company, and ending the omnibus with the formal complaint of Miranda Edwards versus the Duquesne Light Company.
Is there a motion to consider the staff recommendations?
So moved.
Is there a second? Motion made by Vice Chair Barrow, seconded by Commissioner Unora. Any discussion? Hearing none. All those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it, and matters passed by a vote of 5-0. Madam Secretary.
Turning to page 6, it is recommended that the Commission adopt the proposed opinion and order in the formal complaint of Michael and Sharon Hartman versus PPL Electric Utilities.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Coleman. Any discussion? I do have a motion. I ask that Vice Chair Barrow chair the meeting.
Thank you. Chairman, you're recognized for the purpose of your motion.
Thank you, Vice Chair Barrow. Before the commissions are the exceptions of Michael and Sharon Hartman and PPL Electric Utilities Corporation to the initial decision of Administrative Law Judge Stephen K. Haas issued October 3rd, 2023. This matter involves a formal complaint implicating the adequacy of service provided by PPL. The adequacy of service dispute arises in connection with PPL's construction and construction-related activity involving the Halifax-Dauphin 69 kV transmission line rebuild project. The Hartmans raised several claims in their complaint. The essential allegations were stated as follows. PPL has violated the existing right-of-way agreement on our residential property and has failed to compensate us for damage and removal of our property. Furthermore, PPL has trespassed upon and damaged private property outside the right-of-way. The presiding ALJ concluded that the complainants met their burden of proof concerning inadequate erosion control measures by PPL in connection with the transmission project. I concur. However, upon review of the initial decision, exceptions, and reply exceptions, I submit that further clarity and modification is required to make an appropriate determination on a complainant's exceptions related to reconsideration of environmental claims. In light of the Commonwealth Court's ruling in the Township of Marple versus Pennsylvania Public Utility Commission, complainants seek reconsideration of the claims regarding the environmental impact of PPL's construction practices and the reasonableness of PPL's environmental protection controls. In Marple, the Commonwealth Court determined that the Commission failed to properly apply the requirements of the Environmental Rights Amendment of the Pennsylvania State Constitution in our review and disposition of a petition for exemption of certain local zoning requirements. PPL, via its reply exceptions, asserts that complainants' reliance upon Marple in support of their environmental claims is misplaced. The company distinguished Marple based upon the difference in the statutory provisions of Section 619 of the Municipal Planning Code as compared to Section 601 of the Public Utility Code pertaining to formal complaints. In summary, PPL argues the Commonwealth Court's ruling does not apply because this case is a Section 701 formal complaint proceeding, not a Section 619 proceeding. The ERA places requirements on the Commonwealth and its agencies, including this Commission. I note the Commission's adjudicatory decisions and regulations are subject to the ERA. When a complainant raises quality of service issues in a complaint, which could include environmental issues, they bear the burden of proof to show that utility service is unreasonable, just like any other complaint. Here, the Commission is addressing the merits of the assertions made by the complainants regarding PPL's quality of service, which does include allegations of PPL's impact on the property of the complainants. Consequently, I believe that the exceptions of the Hartmans in the nature of a petition for reconsideration of their environmental claims, as described above, should be denied in part. I find this determination to be consistent with the Commission's recent disposition in Tate versus Columbia Gas of Pennsylvania Incorporated. I offer this determination solely based on the facts and circumstances presented in this instant case. Such a determination is not intended to qualify the universe of circumstances in which this Commission is obligated or not obligated to apply the ERA analysis. Therefore, I move that 1, the exceptions of Michael and Sharon Hartman filed on October 19, 2023, the initial decision of Administrative Law Judge Stephen K. Haas issued October 3, 2023, and the above captioned formal complaint are granted in part and denied in part, consistent with this motion. 2, the exceptions of Michael and Sharon Hartman, treated as a petition for reconsideration of their environmental harm claims, are denied, consistent with this motion. 3, exceptions of PPL Electric Utilities Corporation, filed on October 23, 2023, to the initial decision of Administrative Law Judge Stephen K. Haas, issued October 3, 2023, and the above captioned formal complaint are granted in part and denied in part, consistent with this motion. And 4, the Office of Special Assistants prepare an opinion and order consistent with this motion. Thank you, Vice Chair.
Thank you. Is there a second on the motion?
Second.
Second by Commissioner Yanora. Is there any discussion on the motion?
Vice Chair, I do have a statement on this matter.
Commissioner Coleman?
Thank you. I just asked that my written statement be entered in the record as though I read it in its entirety. Thank you.
Thank you. Any further discussion? Hearing none. All those in favor of the motion say aye.
Aye.
Aye. Any objections?
No.
All right. On final adoption, is there any objection to using the previous roll call? Okay.
Madam Vice Chair, on the final matter, as amended by the motion, I would like to concur in part because I agree that the complainants met their burden of proof concerning PPL's inadequate erosion control measures, but I would like to dissent in part because I prefer OSA's broader language relating to the Commission's obligations under the Environmental Rights Amendment. But for the purposes of recording my vote, you may record me as a yes.
Thank you, Commissioner. All right, so on the motion passes by a vote of 4-1. The matter as amended by the motion passes 5-0. Thank you.
Chair, Madam Secretary.
Continuing on page 6, it is recommended that the Commission adopt the proposed opinion and order in the formal complaint brought by the Bureau of Investigation and Enforcement versus the Westover Property Management Company, LP.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion by Commissioner Zerfas, seconded by Vice Chair Barrow. Any discussion?
Chairman, I have a conflict statement.
Vice Chair Barrow.
Thank you. Kayla Ross, who works for me, used to work in I&E, and she worked on this case. She has not advised me on this matter. Thank you.
Thank you. Any further comments? I do also have a conflict statement. Before joining my staff as legal counsel, Stephanie Weimer was employed in the Commission's Bureau of Investigation and Enforcement and worked on this proceeding. Please note she has not advised me in this matter. Any further comments? I do have a statement I would like to enter into the record. Any further comments?
Chairman, I do have a joint statement with Commissioner Yonora.
Mr. Coleman.
Thank you. Commissioner Yonora and I would ask that our joint statement be entered into the record as though we read it in its entirety. This case involves complex questions of which government entity has responsibility for various aspects of natural gas delivery to the public. The Commission should avoid unilaterally and potentially uninformed decisions involving the jurisdiction of other Commonwealth agencies and large number of governmental subdivisions. Nowhere is it more important than in natural gas safety. Responsible governance requires that we avoid regulatory confusion or the creation of regulatory voids. We believe the issues here are important enough to require a more comprehensive analysis than what is proposed here. We agree with Westover exception number 1 regarding the correction of ordering paragraphs 7 through 10. We also agree in part with Westover's exception number 2. It illustrates how an overly broad interpretation of Act 127 may conflict with the construction code and the International Fuel Gas Code as adopted under regulations of the Pennsylvania Department of Labor and Industry. This potential conflict requires further analysis. However, we don't agree that this potential conflict exempts master meter distribution systems from Act 127 jurisdiction in all circumstances. We further agree in part with Westover exception number 3 that the elements of the definition of a master meter system are not satisfied where Westover uses gas to generate heat and hot water for tenants who are not the ultimate customers of natural gas. This is not to say the Commission's jurisdiction could never reach any part of such a distribution system. Rather, we believe the Commission is obligated to clearly define how each jurisdiction might arise prior to taking enforcement action. The Commission has not done so here. While we agree with Westover's exception in part, we also find the terms of the parties' proposed partial settlement are in the public interest. As such, we concur in part and dissent in part and wish to have our vote recorded as no. Thank you.
Thank you, Commissioner Coleman. Any further comments? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no.
No?
The ayes have it by a vote of 3-2, noting the dissents of Commissioners Coleman and Yonora dissenting in part and concurring in part.
Correct.
Madam Secretary.
Turning to page 7, it is recommended that the Commission adopt the proposed opinion and order in the formal complaint brought by the Bureau of Investigation and Enforcement versus the Philadelphia Gas Works.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Zerfus, seconded by Vice Chair Barrow. Any discussion?
Chairman, I have two statements.
I do too. Go ahead. You first.
Thank you. First, my conflict statement. Kayla Ross, who works for me, used to work for I&E. She did not advise me on this matter. And with regard to my actual statement, Madam Secretary, please enter this into the record as though I read it in its entirety. On December 19, 2019, a natural gas explosion in Philadelphia killed 2 people, Brian Dew and Rudy Cambong. The settlement before us closes out I&E's formal complaint against PGW. Pennsylvanians have been heating homes and cooking with natural gas since the beginning of the last century. And explosions like this remind me that maximizing our investment in utility infrastructure, as well as investing in the training of the men and women in the trenches doing the backbreaking work of replacing underground utilities, including century-old cast iron, natural gas, and water pipes, is our best bet at getting as close as we can get to to a 0 incident rate. I note that no culpability has been assigned for this explosion, and I agree that we should not levy a civil penalty against PGW. PGW does not have shareholders, and civil penalties go right into the other customers' bills. The settlement terms, which seek to improve the underground street trouble investigation protocols and PGW's damage prevention outreach, should result in safer operations. I also expect that PGW's application for PHMSA grants to assist with main replacement will prove beneficial. I am especially interested in the $800,000 that the company is going to spend on methane detectors for customers. I ask that PGW and the Commission's gas safety personnel carefully monitor and report back on whether that investment in the methane detectors is proving effective or should be expanded. Thank you.
Thank you, Vice Chair Barrow. Any further comments? I also have a conflict statement. Before joining my staff as legal counsel, Stephanie Weimer was employed in the Commission's Bureau of Investigation and Enforcement and worked on this proceeding. Please know she has not advised me in this matter. And I also have a joint statement with Commissioner Zerfas that I will read. Before the Commission for consideration is the proposed settlement, along with the recommended decision and exceptions thereto, filed on August 18th, 2023 by the Commission's Bureau of Investigation and Enforcement and the Philadelphia Gas Works. The proposed settlement resolves allegations raised by I&E in its formal complaint filed on July 15th, 2022. These allegations regard PGW's actions relative to a natural gas explosion on December 19th, 2019. The incident is alleged to have been indirectly caused by excavation and construction work previously done at the location. That explosion, which occurred at South 8th Street, Philadelphia, resulted in 2 fatalities, the evacuation of approximately 60 residents, and extensive property damage. It is with heavy heart that this Commission makes a determination on this proceeding today. There is nothing more serious and dire than a loss of life. When evaluating the prudence of this settlement today, we are guided by the intent of preventing such tragedies from occurring again. We believe this goal is the most honorable way to respect the lives of those lost. The settlement exhibits PGW's commitment to spend considerable time and money on remedial and enhanced safety measures that will help prevent reoccurrence of catastrophes like this. Key settlement terms include the following: enhanced coordination efforts with the excavation communication, including distribution of cast iron damage prevention brochures; enhanced coordination with the Philadelphia Water Department, including efforts to routinely meet and provide training concerning the protection of PGW cast iron infrastructure; pursuit of up to $125 million in grant funding from the Pipeline and Hazardous Materials Safety Administration's Natural Gas Distribution Infrastructure and Modernization Grant Program; commitment to shorten the time frame for cast iron main replacement in its next long-term infrastructure improvement plan filing; revising its underground street troubles process, procedures, and training to better assess and respond to events and observations pertaining to cast iron infrastructure; and investing up to $800,000 in a residential methane detector pilot program. Particularly, we believe the residential methane detection pilot represents a significant step toward preventing such explosions in the future, and we commend I&E and PGW for agreeing to this important measure. We also note the absence of any civil penalty in this settlement. This highlights the challenging nature of the Commission's jurisdictional enforcement over its limited subset of municipally formed entities. If this proceeding involved jurisdiction over traditional investor-owned utilities, we will likely be considering imposition of a civil penalty, and such civil penalty will be barred from recovery in the IOU's rates. Such enforcement measures carry significant weight and influence since shareholders of IOUs ultimately bear this risk. However, municipal entities such as PGW do not have shareholders, and any civil penalty assessed will likely be recouped from PGW's own customers. While this in and of itself does not eliminate consideration of civil penalties for utilities situated like BGW, it does require the Commission to be cognizant of such circumstances and to consider enforcement measures outside of traditional civil penalties. For this reason, we find this settlement to be in the public interest and support approval. Any further comments? Hearing none, all those in favor, please say aye.
Aye.
Those opposed, no. The ayes have it, and the matter passes by a vote of 5-0. Madam Secretary.
Continuing on page 7, it is recommended that the Commission adopt the proposed opinion and order in the application filed by American Broadband and Telecommunications Company.
Is there a motion to consider the staff recommendation?
So moved.
Motion made by Commissioner Nora, seconded by Vice Chair Barrow. Any discussion?
Chairman, I have a conflict statement.
Vice Chair Barrow.
Thank you. Kayla was really busy. Kayla Ross worked for I&E before coming to work for me. She worked on this case. She has not advised me on this matter.
Sounds like Christian and Festus have been busy this week. Any further comments? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it, and the matter passed by a vote of 5-0. Madam Secretary.
Turning to page 8, it is recommended that the Commission adopt the proposed opinion and order in the formal complaint of Todd Elliott Koger versus the Duquesne Light Company.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Coleman, seconded by Commissioner Zerfus. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it. Matter passes by a vote of 5-0. Madam Secretary.
Continuing at the bottom of page 8, it is recommended that the Commission adopt the proposed opinion and order in the petition and formal complaint filed by the Citizens Telephone Company of Kecksburg et al. Versus Next Gen Communications.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Zerfus. Any discussion? I do have a motion in this matter. I ask Vice Chair Barrow to chair the meeting.
Thank you. Chairman DeFrank, you are recognized for purposes of your motion.
Thank you. I ask my motion be entered into the record as if I read it in its entirety. Before the Commission today for consideration of the exceptions filed by Next Gen Communications Incorporated to the recommended decision issued by the Office of Administrative Law Judge in this matter on August 30th, 2024. Next Gen is under contract with the Pennsylvania Emergency Management Agency for the provision of Next Generation 911 service, or NG 911. NG 911 service is an internet-based replacement of the existing 911 emergency calling system known as E911 that provides additional functionality and improves operability beyond current 911 service in Pennsylvania. Pursuant to Act 12 of 2015, PEMA is responsible for implementation of NG 911. This matter formally began with the filing of a petition and complaint for arbitration of interconnection rates, terms, and conditions by 21 rural local exchange carriers. The petition and complaint was filed to establish an interconnection agreement with NextGen for the provision of NG 911 services in the Commonwealth as part of the traditional 911 service. The RLECs play a major role in the provision of 911 service. Following the development of an evidentiary record of more than 1,000 pages, the ALJ recommended that the RLECs should not be required to build out their networks beyond their respective service territories to connect to NextGen's designated points of interconnection. The ALJ has also recommended the parties should be directed to further negotiate the details of such interconnection, including cost recovery, or file a petition for arbitration if an agreement cannot be negotiated. In response to the RD, NextGen filed multiple exceptions. Of note, during the pendency of this matter before the OALJ, the Federal Communications Commission issued a report and order on July 19, 2024, seeking to expedite the transition to NG 911 service, help ensure the nation's 911 system functions effectively, and support deployment of advanced 911 capabilities, including video, text, and data that will help first responders save lives. It is with the FCC's recent action and the evidentiary record developed here in mind that we address the exceptions filed by NextGen in this matter. In particular, We reverse the RD to the extent that it does not require the RLEX to build facilities or construct additional networks to connect to NextGen's designated points of interconnection. As such, we grant NextGen's exception number 2 in this regard. We agree with NextGen that Act 12 of 2015 provides PEMA with the authority to establish points of interconnection for the NG 911 system. Similarly, the FCC has determined, among other things, that originating service providers, in this case the RLEX, are responsible for transmitting 911 calls from their service territory to the points of interconnection established by the NG 911 provider, in this case NextGen, even if those points of interconnection are outside the originating service provider's service territory. The FCC recognized that the RLEX have the option to comply using a build or buy approach, noting that the RLEX are responsible for transmitting calls outside their territory and use third parties to do so. We also reversed the decision of the ALJs to direct the parties to further negotiate the recovery of the cost of that interconnection, either amongst the parties or through formal arbitration, as discussed in the Federal Telecommunications Act of 1996. The FCC's report and order provides that in absence of alternative cost arrangements, the originating service providers, in this case the RLEX, will be financially responsible for the cost of transmitting 911 traffic to the NextGen designated points of interconnection. Similarly, the FCC's report and order prohibits the RLEX from seeking recovery of the cost for providing NG 911 services from NextGen or PEMA. Accordingly, as the RLEX are required to build or buy their networks to the points of interconnection, and the FCC report and order states that the RLEX cannot recover those costs from PEMA or NextGen, the outstanding issues between the RLEX and NextGen are resolved through this order, and a remand is not necessary. Our actions today are consistent with Act 12 of 2015 and with the FCC's recent report and order. While we agree with the presiding officers that the parties should continue to engage in direct talks and negotiate in good faith to resolve any remaining outstanding issues in this matter, the parties have already had ample opportunity to negotiate a resolution, but have not been able to do so. Given the public importance of this matter, and that time is of the essence regarding the provision of these emergency services, we believe it is necessary to reverse the RD as discussed herein. As such, the relief requested by the RLEX in their petition and complaint is denied. The remaining exceptions filed by NextGen are granted in part and denied in part, consistent with this motion. Therefore, I move that 1, that the recommended decision of Administrative Law Judges Stephen K. Haas and Gail M. Chiodo, issued at this docket and dated August 30th, 2024, is affirmed in part and reversed in part, consistent with this motion. 2, that the exceptions filed by NextGen Communications, Inc. at this docket are granted in part and denied in part, consistent with this motion. 3, that the petition and complaint filed by Citizens Telephone Company of Kecksburg et al. At this docket is granted in part and denied in part, consistent with this motion. 4, that the Office of Special Assistants prepare an order consistent with this motion. And 5, that this matter be marked closed. Thanks, Vice Chair.
Thank you. Is there a second on the motion?
Second.
Seconded by Commissioner Surface. Any discussion on the motion? Hearing none. All those in favor of the motion say aye.
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 Any objections? On final adoption, is there any objection to using the previous roll call? No. Hearing none, the recommendation is adopted as amended by the motion by a vote of 5-0. Thank you.
Thank you, Vice Chair. Madam Secretary.
Turning to page 9, it is recommended that the Commission adopt the proposed opinion and order in the petition filed by the PECO Energy Company's Electric Division regarding its default service program.
Is there a motion to consider the staff recommendation? So moved. Is there a second?
Second.
Motion by Commissioner Yanora, seconded by Commissioner Coleman. Any discussion?
Mr. Chairman, I just have a quick verbal statement.
Commissioner Surface.
Thank you. Upon review, I do not believe that the petitioners satisfy the legal standards for reconsideration in this case. However, consistent with my vote on the Commission's prior order, I continue to believe that the non-unanimous settlement filed in this case should have been approved in full without modification. I do not support the modification of the settlement relating to PICO standard offer program and am in favor of the settlement provision that allowed customers to return to default service upon the conclusion of their SOP contract. That settlement provision, I think, is in the public interest because it serves to protect customers from unexpected and often large increases in their supply charges when their SOP contract ends. So for these reasons, I will be concurring in result only. Thank you.
Thank you, Commissioner Zerfus. Any further comments?
Chairman, I have a statement.
Vice Chair Barrow.
Madam Secretary, please enter this statement into the record as though I read it in its entirety. I will not, but it's probably going to feel like I did because it's kind of long. The Commission modified PICO's default service settlement by striking the settling parties' agreement that SOP customers could opt to return to default service ahead of time, at the time that they signed the SOP contract. Today, we're voting on the petitions for reconsideration filed to that, our decision on that. And I believe that those petitions should be granted. A properly designed standard offer program is beneficial to customers. During the SOP term, the customers are almost guaranteed to save money compared to the EDC price to compare. So the benefit of a SOP is that it introduces residential customers to the competitive retail market. But recall that the standard offer program is designed to be shopping with training wheels, in that you've got the trusted EDC introducing the customer to the EGS, who's serving as the standard offer supplier. And that standard offer price is a no-brainer because it's pretty much guaranteed to save that customer money over the PTC. But also recall that this SOP customer was, a lot of the times, wasn't even actively looking to shop. They might have called the EDC for an unrelated service issue, and these savings literally fall into their lap. So the ease with which those savings come is part of the problem. Savings are great, but we've got customers who were not looking to shop. So look at SOPs within the context of the greater competitive retail market. In that market, to consistently save money, you have to be a proactive shopper, because passive shoppers generally are not going to consistently realize savings over the price to compare. The reason for that is that the EDC default service auctions are hedged competitive procurements. And so beating the price over time of that does take some effort. Our commercial and industrial customers reap big savings, and this is because they are extremely active shoppers. They monitor the energy markets, the trends, and the contract terms. And they also have great bargaining power. From 1990 to 2014, commercial and industrial electric prices fell by approximately 15% across retail choice states. For residential customers, it's more like 2%. I'm not saying that residential customers don't also save money in the retail market. Some of them do. But those customers actively compare EGS offers. They monitor contract terms and they monitor expiration dates. Even though SOP customers receive notices prior to the end of their SOP contract term, advising of the expiration and their options, many fail to act, and they are rolled into a higher, never lower, mind you, monthly contract, month-to-month contract. And like I pointed out before, many of these customers were not looking to shop in the first place. That was not their frame of mind. So it's not surprising that when they get those notices, sometimes they just don't act on them. And then they're exposed to month unilaterally determined EGS contracts, which, depending on the time of year, can result in really high energy bills for them. So as a matter of policy, I believe that the commission made the wrong call on PECO's SOP. I also believe that continuing PECO's SOP while denying customers the option to direct that they be returned to default service at the time that they sign that contract is legally problematic. And please see my written statement for those legal reasons. Thank you.
Thank you, Vice Chair Barrow. Any further comments? I do also have a statement in this matter that I will submit for the record. Any further comments? Hearing none, all those in favor, please say aye. Aye. Those opposed, no.
No.
The ayes have it, and the matter passes by a vote of 4 to 1, noting the dissent of Vice Chair Barrow. Madam Secretary.
It should be noted that the second item on page 9, the formal complaint of Raman Bush versus the Philadelphia Gas Works, has been postponed for the public meeting of January 23rd, 2025. Turning to page 10. It is recommended in an omnibus motion that the Commission adopt both items on page 10, beginning with the formal complaint of Kathleen McCullough versus the Peoples Natural Gas Company, LLC, and including and ending the omnibus on page 11 with the application filed by Babu Home Care Agency and Babu Non-Emergency Medical Transportation, LLC.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Coleman. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it by a vote of 5 to 0. Madam Secretary.
Continuing on page 11, it is recommended that the Commission adopt the proposed opinion and order in the application filed by Pocaton, LLC.
Is there a motion to consider the staff recommendation?
So moved.
Motion made by Commissioner Yanora, seconded by Vice Chair Barrow. Any discussion?
Chairman, I do have a motion on this matter.
Commissioner Coleman.
Thank you. I ask that my motion be entered into the record as I read it in its entirety. On July 16th, 2024, Christopher R. Manhold, on behalf of Pocaton LLC, filed an application for a paratransit authority. The Commission denied the application by the secretarial letter issued on August 20th, 2024, for failure to fully respond to the Commission's data request. Pocaton filed a petition for reconsideration of staff action on September 6, 2024. Pocaton has provided additional information to correct the deficiencies identified in the secretarial letter. The Commission may exercise its discretion to overlook an error of procedure where it's necessary to secure the efficient resolution of a matter, so long as the substantive rights of other parties are not adversely affected. Noting Pocaton's good faith attempt to provide the requested information, as well as its willingness to cooperate, I find that this matter should be referred to the Commission's Bureau of Technical Utility Service to continue processing the application and allow Pocaton an additional 30 days in which to provide the required information. Therefore, I move that the petition for reconsideration from staff action filed by Pocaton LLC is granted, consistent with this motion, and that the Office of Special Assistants prepare an opinion in order consistent with this motion.
Thank you, Commissioner Coleman. Is there a second? Second. Seconded by Commissioner Yanora. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it, and the motion passes by a vote of 5 to 0. On the matter as amended by the motion, is there any objection to taking previous roll call? Hearing none. Matter passes as amended by a motion by a vote of 5 to 0. Madam Secretary.
Turning to page 12, in matters presented by Director Diskin and the Bureau of Technical Utility Services, it is recommended that the Commission adopt the proposed order regarding the application filed by the Pennsylvania American Water Company to provide water service to Amwell Township, Washington County, Pennsylvania.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Coleman. Any discussion? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it, matter passes by a vote 5-0. Madam Secretary.
Continuing on page 12, it is recommended that the Commission adopt the proposed order regarding the application filed by the Pennsylvania American Water Company to provide water service to Salem Township, Luzerne County, Pennsylvania.
Is there a motion to consider a staff recommendation? Is there a second?
Second.
Motion made by Commissioner Yanora, seconded by Vice Chair Barrow. Any discussion? I do have a statement in this matter. I ask my statement be entered into the record as though I read it in its entirety. Today, the Commission considers the application of the Pennsylvania American Water Company to furnish water service to an additional portion of Salem Township, Luzerne County. The impetus of the application is a request from Amazon Data Services for water service to a proposed data center site, which at full build-out is expected to consist of 16 buildings with nearly a gigawatt of energy demand. As a major exporter of electric generation and with an abundance of water supply, Pennsylvania is well situated for the development associated with data centers and to support American technology companies in their efforts to build artificial intelligence systems. While Pennsylvania is eager for the economic development that construction of data centers will bring to the Commonwealth, including Salem Township and the surrounding area, I believe we cannot lose sight on the importance of properly planned economic development. Based on a review of PAWC's application, it is apparent that the proposed water service for the data center is well planned. For example, Amazon will fund the installation of a water main extension system and 24 public fire hydrants along the main extension route. Amazon will also pay for the installation of a 1.5 million gallon water storage tank and will contribute to the incremental costs associated with its use of a PFAS treatment facility. Both the water storage tank and the PFAS treatment facility are designed to meet the added demand of the data center and provide increased reliability for PAWC's entire Berwick water system. For these reasons, I am pleased to vote in support of the application. Any further comments? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it, matter passes by a vote of 5-0. Madam Secretary.
Turning to page 13, in matters presented by Chief Counsel Screven and the Law Bureau, it is recommended that the Commission adopt the proposed order regarding the rulemaking for the use of a fully projected future test year.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Zerfus, seconded by Commissioner Coleman. Any discussion?
Chairman, I have a statement.
Vice Chair Barrow.
Thank you. Please enter this statement into the record as though read in its entirety. Today, we're addressing numerous changes to our fully projected future test year rules. There are two improvements to the rules that I would have liked to see. First, I would set the threshold for filing a complete set of data at 3 million instead of 5 million. And given, I don't think this is a onerous requirement. And second, I would require that utilities provide various DISC, LTIP, and annual asset optimization plan details with their rate cases. This kind of information provides context for the rate case and provides an important check on the LTIP and the annual optimization, the annual asset optimization plan processes as well. Rate cases are often the principal method by which some organizations participate in utility review, and not all interested parties can participate in all cases. So I would prefer to see this information included in the filing. Thank you.
Thank you, Vice Chair Barrow. Any further comments? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no. The ayes have it. Matter passes by a vote of 5-0. Madam Secretary.
Continuing on page 13, it is recommended that the Commission adopt the proposed implementation order adopting regulations of the Federal Communications Commission creating a rapid broadband assessment team for expedited resolution of pole attachment disputes.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Commissioner Coleman, second by Commissioner Yenora. Any discussion?
Chairman, I do have a verbal statement.
Vice Chair Barrow.
Thank you. I dissented on the October 8th, 2024 order, which directed the Law Bureau to draft this implementation order regarding the adoption of the FCC's Rapid Broadband Assessment Team, or RBOT. While I agree with the concept of accelerating the dispute resolution process for pole attachments, I disagree that the Commission's regulations at Chapter 77 allow the Commission to adopt the provisions of 47 CFR Section 1.736 and 1.737. Our ability to complete automatic adoption is pursuant to Chapter 77 of the Commission's regs, specifically Sections 77.4 and Section 77.5B, which limit our adoption to Subpart J, and which specifically employ the Commission's procedural requirements in Chapters 1, 3, and 5. Here, I believe a better approach would be to initiate rulemaking to adopt an accelerated docket consistent with the Commission's policies, procedures, and structure. Consistent with my prior votes, I'll vote no on this today. Thank you.
Thank you, Vice Chair Barrow. Any further comments? I do have a statement in this matter. I ask my statement be entered into the records that I read it in its entirety. Before the Commission today for consideration and implementation order in response to the Commission's order entered October 8th, 2024 at this docket. In that October 8th order, the Commission adopted Section 1.1415 of the Federal Communications Commission's regulations consistent with the Commission's own pole attachment regulations. Section 1.1415 requires the development of a rapid broadband assessment team to facilitate expedited dispute resolution procedures for disputes between pole owners and attachers, and became effective at the federal level on July 25th, 2024. In the October 8th order, the Commission recognized the expedited nature of the FCC's process. Deploying broadband services throughout Pennsylvania is fundamentally important to providing access to medical care, retail services, education, economic development, and much, much more. Expediting the resolution process for broadband disputes will help increase the ongoing efforts to ensure Pennsylvanians, particularly those in rural and underserved areas, receive the broadband services they need. By shortening the dispute resolution process, we are reducing barriers to broadband deployment and ensuring that infrastructure investments can be made more swiftly and effectively. Given the public importance of deploying broadband services throughout the Commonwealth, the action we take today reduces the timeline for our process by between 1/3 and 1/2. Therefore, I'll be voting in favor of the implementation order. I suggest the Commission's pole attachment working group continue to consider how we can effectively and efficiently reduce the amount of time it takes to resolve these disputes. Those residents of the Commonwealth who still receive broadband services at reduced speeds or not at all deserve nothing less. Any further comments?
Mr. Chairman, I would like to associate myself with your comments.
Thank you. Commissioner Surface, any further comments? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no.
No.
The ayes have it. The matter passes by a vote of 4-1, noting the dissent of Vice Chair Barrow. Madam Secretary.
Turning to page 14, in matters presented by Chief ALJ Rainey and the Office of Administrative Law Judge, it is recommended that the Commission adopt the initial decision of ALJ DeVoe in the formal complaint of the Bureau of Investigation and Enforcement versus Columbia Gas of Pennsylvania.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Zerfus. Any discussion?
Chairman, I have a conflict statement.
Vice Chair Barrow.
Thank you. Prior to joining my staff, Kayla Ross worked for INE, and she worked on this case. She has not advised me on this matter. Thank you.
Thank you, Vice Chair Barrow. Any further comments? I do have a statement in this matter, in this case. I ask my statement be entered into the record as if I read it in its entirety. Before the Commission is the initial decision of Administrative Law Judge Emily DeVoe, which approves the settlement agreement between the Bureau of Investigation and Enforcement and Columbia Gas of Pennsylvania. The settlement results from INE's investigation of a natural gas explosion that occurred on October 29th, 2020 in Harrisburg, Pennsylvania. The explosion severely damaged a residence, resulting in its total loss and caused the evacuation of approximately 19 residents living within a 2-block radius. INE determined that the natural gas leak originated from a failed fusion on a 2-inch plastic main, which was located in front of the residence that was destroyed. This leak was the source of the gas that migrated into the home, eventually igniting. The 2-inch plastic main was installed in 1982 and was the subject of 3 documented leak repairs. The most recent leak repair prior to the explosion took place on March 6, 2020. In its formal complaint, INE alleges that the actions of Columbia Gas violated various provisions of Part 192 of the Federal Pipeline Safety Regulations, as well as Sections 1501 of the Public Utility Code. Notably, INE alleges that Columbia Gas failed to properly heat fuse the pipe joints on the 2-inch plastic main when it was constructed in 1982 and failed to identify defective fusion joints when subsequent repairs were made. INE and Columbia Gas engaged in a series of discussions that culminated in the filing of the settlement agreement that is being considered today. The terms of the settlement agreement are comprehensive and, in my opinion, precisely address the important issue concerning the identification and replacement of older plastic pipe materials installed between 1960s and the 1980s. This topic is the subject of a motion I offered at the August 1st, 2024 public meeting, which resulted in a tentative order entered by the Commission on August 26, 2024. The tentative order notes that several advisory bulletins warned of the risk associated with older plastic pipe, which can experience brittle-like cracking. The brittle-like cracking can occur due to improper joining or installation. The tentative order proposes, among other things, that natural gas distribution companies, like Columbia Gas, simultaneously focus on the replacement of older plastic pipe in addition to the removal of other at-risk pipe materials such as cast iron and bare steel. The terms of this settlement set forth a blueprint on how to effectively identify and replace older plastic pipe. For example, Columbia commits to revise its Distribution Integrity Management Program, or DIMP, to incorporate a granular breakdown and analysis of older plastic pipe, expand its DIMP risk assessment to evaluate data from testing and reporting of all failures involving older plastic pipe, and from an inspection of all exposed older plastic pipe fusions that are found to be visibly unacceptable. Implement a GIS system to capture data concerning older plastic pipe. Add an accelerated action to analyze on a quarterly basis open and closed leaks suspected or confirmed to be on vintage plastic pipe, and to take appropriate action based on the analysis. Begin accelerating the replacement of older plastic pipe without impacting the pace of Columbia's removal of cast iron, wrought iron, bare steel, and unprotected coated steel pipe in its distribution system. And destructively test at least 15 older plastic pipe fusions annually to determine the risk associated with these older plastic pipes. Columbia agrees to continue the destructive testing for a minimum of 5 years. Those and other remedial measures, in addition to Columbia's payment of a $700,000 civil penalty, are designed to benefit public safety and prevent similar incidents from recurring. While the October 2020 explosion in Reimersburg was certainly a tragedy, we can learn from disasters and implement actions to reduce future risk. The settlement that is before us embodies this notion, and I commend the parties for achieving positive public benefits arising from a serious incident. For these reasons, I'm voting to support the adoption of the initial decision and approval of the settlement in its entirety. Any further comments? Hearing none, all those in favor, please say aye. Aye. Those opposed, no. The ayes have it, matter passes by a vote of 5-0. Madam Secretary.
Finally, it is recommended that the Commission adopt the initial decision of ALJ Heath in the formal complaint of Frank Capozzi Sr. versus the Pennsylvania American Water Company.
Is there a motion to consider the staff recommendation?
So moved.
Is there a second?
Second.
Motion made by Vice Chair Barrow, seconded by Commissioner Reserve for the same discussion.
Chairman, I have a statement.
Vice Chair Barrow.
Thank you. Please enter the statement as though read in its entirety. Frank Capozzi Sr. filed a formal complaint against Pennsylvania American, alleging that he was billed for service that he did not use. At the hearing, the complainant testified that prior to temporarily vacating the premises for a number of years, he asked his friend, Ms. Shealy, to contact Pennsylvania American and his other utilities to discontinue his service. Ms. Shealy also testified at hearing to support this claim. The complainant argues that despite that notice from her, Pennsylvania American failed to turn off the water service. Pennsylvania American responded, saying that it has no record of Ms. Shealy contacting the company in January 2019 to shut off service, and they argue that as the ratepayer of record, Mr. Capozzi is responsible for the usage. The company further argued that the complainant's daughter made payments on the account during the period in question and even entered into a payment arrangement to reconnect the service after Pennsylvania American later terminated service for non-payment. The initial decision found that the complainant did not live at the service address for the 4-year period in question, and the ALJ opined that Ms. Shealy credibly testified that in January of 2019, she called the company and asked for service discontinuance. The ALJ noted that Pennsylvania American failed to provide supporting contact records for early 2019, and as a result, the ALJ sustained the complaint and assessed a civil penalty of $175. I disagree with the ALJ's decision. I do not believe that this complainant presented sufficient evidence to satisfy his burden of proof. The evidentiary record relied upon to find that the complainant is not responsible for the usage, which accrued during his absence, is not convincing to me. There's a couple of holes that I see. One is that the complainant's friend is not sure of when she allegedly placed this call to the company, and the record does not reflect what information, if any, she received from the company regarding winding up the account. That's what normally happens when you call to discontinue service. Also, I do not believe that any negative inference can be drawn from the fact that Pennsylvania American does not have the 2019 call records. By the time this matter came up for adjudication, the 4-year record retention period had already run. The burden of proving lack of responsibility for the $3,700 in charges that accrued on the account during the complainant's absence lies with the complainant, and I just don't believe that he met that burden of proof. I go back to the fact that Mr. Capozzi's daughter made payments to the account and entered into a payment arrangement during the period in question. I can't say for sure whether she's the responsible party, but it doesn't appear to me from this record that the rest of Pennsylvania American's ratepayers should be responsible for this money, because the complainant has not met his burden of proving that he, as the ratepayer of record, is not responsible for the charges accrued during January 2019 to May 2023. I believe the complaint should be dismissed.
Thank you, Vice Chair Barrow. Any further comments?
Chairman, I do have a statement as well.
Mr. Coleman.
Thank you. I'm going to be voting no on the adoption of this initial decision, and I would just ask that my statement be entered in the record as though I read it in its entirety. Thank you.
Thank you, Commissioner Coleman. Any further comments? Hearing none, all those in favor, please say aye.
Aye.
Aye. Those opposed, no.
No.
The ayes have it, and matter passes by a vote of 3 to 2, noting the dissents of Vice Chair Barrow and Commissioner Coleman. Madam Secretary.
Mr. Chairman and Commissioners, that concludes all agenda items to be considered today.
If there is no other business to come before the commission, is there any objection to adjourning? Hearing none, we are adjourned.